Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and they shall be heard.
Thank you. Please be seated. First case on for argument today is case 794, People v. Santiago.
Good morning, Your Honors, and may it please the Court. Daniel Maddle appearing on behalf of the people in this matter. I would just like to supplement the people's position added in the briefs by noting the fact that the defense counsel on this matter failed to submit opposing papers. Therefore, the people's position would be that any opposition is conceded and the people would ask for the relief outlined in the brief. That being said, the people are available if the Court has any questions or concerns.
No questions, counsel. Thank you.
Thank you.
Case 795, People v. Lafferty.
May it please the Court, Bridget Field on behalf of Mr. Lafferty. I would submit on my papers unless the Court has any questions in this case.
No questions, counsel.
Thank you, Your Honor.
Thank you. Case 796, People v. Finster. We have Mr. Keem appearing by video. Mr. Keem, can you hear us?
I can, Your Honor.
Very good. Thank you. We have counsel present. Please proceed.
Good morning. The calendar, I guess, is just flying today because I am also, unless the Court has any questions, going to rely on my brief.
No questions, counsel.
Good morning. May it please the Court. Chris Eagleston for the response, and I'll do the same if it pleases the Court.
Very good. We have a rocket docket today. Very good. Thank you, counsel. Case 798, Nichols versus Nichols.
May it please the Court, good morning.
Well, let's hold on one second to your counsel get, co-counsel get their opponents get situated. All right, proceed, counsel.
Thank you. Michael Schmidt for petitioner respondent, who's the grandmother in this case. Just to highlight the arguments I make. This is a grandparent visitation case, and it's our argument that the grandmother failed to establish that she had standing. The courts generally recognize grandparent standing when there's a refusal by the parents to allow the grandparents to visit with the children. In this case, that was not what happened. The grandmother testified succinctly. She clearly established that she had stopped asking the mother for visitation and was getting visitation from the father quite regularly. On cross-examination, there was a fair amount of testimony where she said that the grandmother was
Does the father have sort of limited access as well?
Father had every other weekend, 2 evenings during the week.
So granting the grandmother access was really taken away from the father.
It wasn't really taken away. Mother wasn't afforded the opportunity by grandmother prior to grandmother asking for an order to give her a visit. So the testimony was, mother says, I'm mad at mom. Grandmother says, I'm mad at mom. I'm not asking mom for visits anymore. And instead, she files a petition against mom, named father as well. And throughout the testimony, she acknowledges, I'm seeing the children a lot. I'm able to see the children whenever I ask dad, and therefore I'm not asking mom at all.
Wasn't there testimony, and you correct me, you know the record better than I do, wasn't there testimony in the record that indicated that there were occasions where there was requests for visitation, and then at the last minute there were a decision to not grant visitation, and it became kind of a frustrated situation where the grandmother was being stopped from seeing the children?
Not really, and specifically if you look at the AFC's brief, I think the AFC tried to make that point. But if you look at the testimony, and if you read what was said, it was sort of a generalized testimony. But then on cross-examination, she says, no, I stopped asking. I didn't ask. She asked, there was an argument in early August.
Would you agree that if we read the record to show that there was frustration and there was when there was agreements and last-minute changes, that might explain the reasons why there was no request for further visitation and then an application was made?
I don't agree with that for the following reason. In August, the beginning of August, there's an argument between mom and grandmother. Grandmother testifies that she asked to see the children the end of August. There was a visit set up that mom had to cancel. And grandma says she didn't ask for another visit until Christmas time. When she asked to see the children at Christmas, she was able to see the children at Christmas. And then between Christmas and even the end of trial, she testified she didn't ask mom at all to see the children. She was saying that I was able to see the children while asking for visits from dad, and she didn't ask at all to see the children while they were with mom.
I think I understand your argument. Thank you, counsel. Anything further?
Just briefly, if the court is going to find that there was standing, I would just ask you to look at this visitation schedule. This grandparent visitation schedule is very significant.
If your client had testified, she could have told the court what would have worked better for visitation. She did not testify.
But the grandmother and the father testified to what the visitation schedule had been up to that point. They each testified that grandmother would see the children on holidays and maybe 5 or 6 times during the year.
But your client could have shown up and testified, hey, this visitation doesn't work for me. This is why it's not in the best interest of the child. Things like that. But there was dead silence on your part because your client didn't testify, correct?
Right, but the schedule doesn't come until after the decision is rendered. So when grandmother testified, I don't know that she specifically requested, well, she did request to see the children, I think, every weekend. What the court ordered was that grandmother would have every single Friday. I mean, there's 52 Fridays in a year, and my client has no ability to ever have the children for a full weekend and go away because grandma gets every Friday. On top of that, it's a split custody scenario. So my client gets every other weekend, dad gets every other weekend. The court says that only mom loses her visitation, and she loses half of her Fridays every month. So in giving grandmother 1 Friday a month, my client gets 2 Fridays a month. It takes away half of my client's Fridays overnights. On top of that, there was a visit smack dab in the middle of Christmas, on Christmas Day, and there's a visit.
So you want us to find there was an abuse of discretion with respect to the amount of visitation that was granted?
Absolutely. And I also think that it's improper to, when we have a split custody case like this, to say that the children are only ordered to see the grandmother on one parent's time. And I think that was error. I mean, and 5 or 6 times a year versus 12 times a year and only with one parent results in my client never having a Friday. The children are with grandmother 4 o'clock on Friday to 7 o'clock on Friday, and then 1 Friday a month overnight to Saturday.
We'll take a look at that, counsel. Thank you.
Thank you.
May it please the court, Gary Muldoon for Nancy Nichols, the grandmother. I should note that my brief contains an error in that I incorrectly assumed that a Lincoln hearing was held, and there was none. So my apologies to the court for making that assumption. This appeal is like Seinfeld. It's about nothing. There is no issue of standing. That was conceded in the court below, record page 193. He said, I am conceded that there is a relationship between the two. I should note, Your Honors, that the mother at trial, she didn't default, but she didn't put in any answer. She called no witnesses, and she did not testify herself. So Justice Kern is correct in pointing out that there was no connection of dispute over certain issues, including actually the amount of visitation. It would have behooved the mother to have presented evidence of her constitutional right to raise a child, that this was somehow impaired. Opposing counsel says that, Mr. Schmidt says that this is a split custody case. It's a joint custody case. The father has joint custody, but he has a far smaller amount of time with the children than the mother has. So when the judge gave a court order, which the father was perfectly content with, and he is not an appellant or respondent on this appeal, he took it from, the judge, the referee, took it from the mother's time, since she has, frankly, the lion's share of the time. I believe the council overstates the amount of time that the final order states that the mother will have. And I would also note that it's not like her weekends are really impaired. She works on a Saturday. She's a hairdresser, and so she's working on Saturday morning. So the grandmother having time on Friday night is not really an impairment of her being able to have a weekend.
In mother's summation I'm looking at now, I don't see any proposal for a specific visitation visitation schedule if the court granted grandmother access. I mean,
Thank you.
there was just a one sentence about, don't give her half the time. But there was no proposal from the mother as to what visitation schedule would work, what would be in the best interest of the children, nothing. Do I have that correct?
I think that is correct, Your Honor. Yes, I believe that is correct. As to the grandmother being denied visitation, there wasn't just an argument. There was a huge blow-up that occurred in the northern part of Rochester in Charlotte that was because the mother saw that the father was spending time with the children. That's why this whole case erupted, why the mother all of a sudden...
Do I have the record correct? The mother learned that the father was spending time with the children during the grandmother's visitation time.
That is correct, Your Honor. And is there anything wrong with that? I would suggest that where two parents have joint visitation and the father seeing the children during the time that the grandmother is there is perfectly appropriate. There's nothing inappropriate about that
And the testimony
whatsoever.
seemed to be that it was by happenstance that he walked into the restaurant where she was with the children, and I didn't see anything contradicting that in the record.
Nor did I, and that's how the referee that's how the referee found. I would note also that counsel has made an argument in his brief that somehow that a referee cannot make findings regarding demeanor in a case where a virtual hearing occurs. I'm completely unaware of any case law that suggests that a virtual hearing, that method of communication prevents a trier of fact from making findings of a person's oppositional
I think we have that
attitude.
argument. Counsel, anything further?
Nothing further. Your Honor.
Thank you.
Excuse me, may it please the court, Maureen Poland from the Legal Aid Society here for the children. I would just note that I have offered cases in my brief that make clear that a grandparent need not be completely denied visitation for that grandparent to have standing to petition for visitation with their grandchild. And I would note that although there's an argument about how much the grandmother was asking the mother for visitation after that argument in August, I would point out that text exchange from December when the mother makes very clear that she is not going to allow the grandmother to have that unsupervised contact with the children that the grandmother and the grandchildren had been regularly enjoying prior to that August visit, or excuse me, that August argument. So I do think that the fact that the grandmother wasn't asking the mother for visits, I do think that the record demonstrates that there were reasons for that, and there were good reasons for that. And I do think that the mother, even if she didn't testify and say it in so many words, she was opposed to the grandmother having that liberal contact, unsupervised contact in the community or in the grandmother's home that the grandmother had been enjoying prior to August.
And you'd ask us to affirm the court below?
I would ask you to affirm the court below, Judge. And if there's no further questions, I would just rest on my brief.
Thank you, counsel.
Thank you.
May I respond to just two
No, you may
points?
not. There's no rebuttal. The next case up for argument is case 804, matter of the estate of Catherine W. Buck. We're calling 804 with 804.1, so we'll have both arguments together. Counsel, you'll be arguing?
Yes, Paul Sweets. So, Mr.
You should have a seat at the table then.
I'm sorry, excuse me here.
Thank you, counsel. Mr. Buckeye, proceed.
Good morning. May it please the court. Craig Buckeye from the law firm of Phillips Lytle LLP on behalf of Stephen Buck, our client, and I'm also arguing today on behalf of Richard Buck. And as Justice Whalen noted at the beginning of argument, this is the argument of two appeals basically at the same time. The one appeal was the first appeal that was perfected back on May 12th, dealing with the merits in this proceeding, but also with respect to a recusal issue to the extent that we were able to address that issue pursuant to the facts that we knew at that time. And then the second appeal is from the denial of the recusal motion once we obtained a fuller view of the facts pursuant to our own independent research and further proceedings that took place before the surrogate on June 15th. What Mr. Steitz and Mr. Martin, on behalf of their clients, are going to ask this court to do today is to affirm the orders that were entered by the surrogate in this matter of estate of Catherine Buck, in which he denied enforcement of the will that Catherine Buck executed on January 17th, 2011, and determined that she lacked testamentary capacity, and the surrogate made that testamentary capacity determination based upon his evaluation in significant part upon her mental condition at the same time that the surrogate was representing the deceased in a litigation matter in Oneida County Supreme Court. We would submit that that is not proper, and even more than not proper, that is not permitted under Judiciary Law Section 14. This is a jurisdictional issue that speaks to the jurisdiction of the court, and if the court does not have proper jurisdiction, then the court does not have any ability at all whatsoever to rule in this matter.
But how was he an interested party?
Well, let's look to the language of Judiciary Law Section 14. It says, "A judge shall not sit as such in or take any part in the decision of an action, claim, matter, motion, or proceeding," and then ellipsis, "in which he has been attorney or counsel or in which he is interested." The statute doesn't say that the surrogate needed to have been an interested party. It says that the surrogate needed to have been interested in the proceeding. And we would submit that absolutely the surrogate was interested in the proceeding because he was interested in the subject matter.
Let me ask you a question.
Yes.
With respect to this contact that the judge had with this case, and you tell me if I've got the record wrong on this. My understanding is that the judge disclosed his contact with the case early in the case, and counsel understood it, acknowledged it, and agreed to let him sit. And then later in the case, before a decision was rendered, again, the court acknowledged this contact with the case. The attorneys again said, no, we're fine with this. And then it proceeded to decision after decision. The argument became, this is a jurisdictional problem. Obviously, if you're right on that point, it doesn't matter that he disclosed. That's your point, right?
Yes.
It just doesn't matter.
Yes.
It's jurisdictional.
Yes.
But you'd agree that if we don't find it's jurisdictional, that he had disclosed this on 2 occasions before a decision was rendered.
Well, here's what I would say. I would submit, Justice Whalen, with all due respect, that that characterization of the record is not entirely accurate for several reasons.
Yeah, where's it lacking?
First of all, with respect to the alleged disclosure that took place at the inception of the case, we don't know, or I certainly don't know, what disclosure there was, because there was, in fact, nothing in the record, this 37-volume behemoth record that we have, there's nothing in there that says what that disclosure was. And in fact, I'd like to turn to the recusal record. There's a provision from the transcript of proceedings from April 7th, 2022, which was the 24th day of the 25-day trial, in which the surrogate, when he was about to admit into evidence the check that bore his signature.
That was Exhibit NN, right?
Exhibit NN, that's correct. The surrogate said, and I'm referring to the recusal record, page 783, the surrogate said, "The reason why I'm doing it meaning the disclosure, and we'll talk about the disclosure on day 24 in a moment. The reason why I'm doing it again now, because the appellate division is going to see this record, if it goes to the appellate division with my name in it. They're not going to see the minutes of our initial court appearances on the proceeding. So the surrogate himself acknowledges that there's no way to know what the disclosure was because it isn't in the record. So that's the first item. The second item is that at the time of the trial, we were not counsel to Stephen Buck. His attorney was Paul Pimpinella. And what's important to remember about Mr. Pimpinella is that he was not involved in the proceeding at the time this alleged initial disclosure was made. He had not entered an appearance at that point. His appearance was not entered until March 2018. And so, on April 7, 2022, the surrogate asks Mr. Pimpinella, would you confirm? This is page 784 of the surrogate recusal record. And Mr. Pimpinella says, Your Honor, I'm not sure I was even involved by that time. I may have been, but I have no objection. And so we would submit, well, he said he had no objection, but he wasn't involved at the previous time. And Mr. Pimpinella is being asked this on day 24 of a 25-day trial, after all of this effort has been undertaken since December to do a trial on various days when the various counsel and witnesses could be all gathered together.
You'd agree, if we find it's not jurisdictional, you'd agree that that was the opportunity there. Even though the trial was wrapping up, that was the opportunity there for counsel to say, Your Honor, I wasn't present previously. I've now looked at this, or I need time to look at this to make a determination.
Well, we would
counsel made the determination and advised the court there was no problem.
Well, we would submit that the recusal issue can be raised at any time, even on appeal. But regardless, even so, even if there's no jurisdictional issue, there's still the mandatory recusal issue under the rules of the Chief Administrative Judge, 22 NYCRR, Section 100.3E. And in order for the surrogate to come within the safe harbor that is set forth in Section 100.3F, first of all, there needed to have been disclosure. And we would submit that it was the job of the surrogate to offer a fulsome disclosure of all of the circumstances that would underlie the possible recusal issue. And all the surrogate said was he spoke of that he had past dealings and familiarity. That's all the surrogate said. And we would submit that in order for there to be a knowing and willful consent, it was incumbent upon the surrogate at that time to give a fulsome disclosure. Simply saying he had past dealings and familiarity with these parties.
Well, as you point out, though, and rightfully so, what was disclosed, the amount of the disclosure early on is not part of the record before us.
Correct.
But if counsel at the second point, when Exhibit NN was being submitted, if counsel wanted to get into that disclosure issue, counsel could have.
Counsel could have, but it's not the job of counsel to ask. It's the job of the surrogate in the first instance to give a fulsome disclosure. And that fulsome disclosure should have included, among other things, number one, all of the different past representations, legal representations, attorney-client, that the surrogate had with a myriad number of witnesses who were testifying in this proceeding. Even more important, the disclosure should have said, look, I happened to represent the deceased from 2007 to 2009. And by the way, I, the surrogate, am of a view that in determining her testamentary capacity, that time period when I was representing the deceased as her lawyer, I consider that time period to be especially relevant in determining whether she had testamentary capacity. We would submit it wasn't relevant at all because the will wasn't signed until January 2011, and what matters is what happened on the day the will was signed.
Let's move into that question, right?
Yes.
So, I mean, moving past the judge recusal issue, as I read your argument, you're saying that the judge just got it wrong with respect to the standard applied relative to testamentary capacity. Do I understand that right?
I would say a number of things. Number one, the standard was wrong, and number two, the application of the standard was wrong. Because in order for one to find that there is a lack of testamentary capacity, first of all, the burden is on the challengers to prove that. Second of all, they have a burden to prove that case by clear and convincing evidence. We're not just talking about a preponderance of the evidence, because it is the policy in the state of New York that as a general matter, we are going to enforce the ability to decide through their will what is to become of their bounty, what is to become of their estate. There are three different inquiries that are often made in determining whether a will is to be enforced. Number one, did the person understand that he or she was making a will?
So is it your contention that when the subsequent will, the will reflected here at the time that the testator was lucid and understood?
Yes, absolutely. The testator knew she was making a will, and in fact, there's no dispute about that. Second of all,
weren't there three witnesses, too, that testified to her
yes,
at the time? The lawyer, the paralegal, and I think the caretaker?
We have three disinterested witnesses. The lawyer who helped to draft the will and who was engaged in the planning process with Catherine Buck for more than a year, speaking with her over the phone, speaking with her in person, at least every couple weeks as part of this planning process. Second of all, we have Ken Lawrence, his paralegal, who was there on January 17, 2011 as one of the witnesses and said, look, she answered questions appropriately, she appeared lucid and rational, she appeared to understand exactly what was going on, and then we have her personal assistant, Teddy Minuti, personal assistant since 1978, who had known Catherine Buck through all these days and observed her at the office, aside from family, there was no one closer to Catherine Buck than Teddy Minuti, and she testified likewise. These are the three people who have nothing to gain, and all of them say we were there on January 17, 2011, she knew what she was doing, she was lucid and rational. And for that reason, even apart from the recusal issue, there was no basis to overturn this will, and in fact, the surrogate should be overturned, such that the will from January 17, 2011 would be enforced.
The surrogate's decision, as I'm reading on page 14, part of it says, the evidence presented at trial portrays Catherine in January of 2011 as a person who did not understand the complexities or values of her property holdings. And is that the right standard to apply, that she needed to know the complexities and the values of her property holdings?
No, not at all. So the only basis upon which, as I read the surrogate's decree, the surrogate determined that Mrs. Buck lacked testamentary capacity is what Your Honor just said. But that is not the standard, because all that the testator...
Is that related to also an insurance policy, which she believed she had enough to cover a trust, a future trust?
Well, I think, Justice Montour, what you may be referring to is she thought that perhaps she had $1 million that could be paid for the benefit of paying down the mortgage on the camp property and then otherwise being used for the benefit of improving the camp. The standard is not that the testator needs to know the precise value of her estate. And we would submit that that is the standard to which the surrogate is holding Stephen and Richard Buck as the proponents of this will. Rather, all that one needs to know is to have a general idea of what one's estate consists of, not with respect to the particular value. And you know what?
And importantly, that's at the time of the execution of
Yes.
the will.
Yes. And so, you know, the fact that the estate was complex, we would submit is of no moment, because lots of things are complex. Math is complex. Calculus is complex. There are loads of complex things that I don't understand and that lay people don't understand. But all that Mrs. Buck needed to understand is who her children were. She knew who her kids were. She was going to give 9 of those kids an allocation per stirpes, and she was leaving 2 of them out. And by the way, the 2 kids who were left out are not challenging this will. And she needed to know the fact that she had these shares of the Richard M. Buck Construction Corporation. And in fact, there was testimony at the trial that as of 2011, it was agreed by the tax preparer, Jim O'Brien, by the CPA, Elizabeth Scully, that these shares were not particularly worth very much because these shares owned partnership interests, general partnership interests in these 6 limited partnerships that owned low-income housing. This wasn't, you know, fancy real estate on the shores of the Atlantic Ocean in Florida. This was low-income housing in Utica, New York, and the surrounding environs. And the CPA and the tax preparer agreed that this property did not particularly have all that much value. And so Catherine decided in her will that she was going to bequeath that property to Richard and to Stephen, her two sons. Why? Because they were running the business. They were intimately involved in the affairs of the business, and frankly, to accept these shares was almost kind of an albatross for them, because at the time, it was simply low-income property, housing projects in and around Utica. What the children and what Catherine could not have necessarily foreseen in 2011 is that within a few years thereafter, there was going to be a change in housing policy under the Obama administration, whereby the Obama administration had concern that low-income housing was being converted into fancy apartments, was being converted into condominiums. And so as a consequence, the federal government, backed by the Department of Housing and Urban Development, was going to give financial incentives to owners of these housing projects to pay them off, to buy back the properties at a premium. And this policy, as was testified at trial, caused the value of these properties to go up significantly by about $15 million. Except January 17, 2011, there was no way to know that that was going to come down the pipe. And so, incidentally, could it be said that Rick and Stephen benefited from that federal policy under the Obama administration? Sure they did, but you know what? That's life. And that just because they had the benefit of what in hindsight happened to be a good deal by which they would have the opportunity to own these shares of the corporation does not authorize the surrogate and does not justify invalidation of a will that was properly made in front of disinterested witnesses who can affirm that she was lucid and rational at the time.
Be mindful of your time.
Yes. And so for those reasons, we would submit that the surrogate applied an improper standard. All Catherine needed to know was the general makeup of her property, and she did. And the one case that I do want to emphasize that the surrogate really relies upon is the Slade case from 1984. And that was a case in which, yes, it was determined that the testator did not know enough about the nature of the property at issue. But what was key to me is that in the Slade case, in that case, the testator was under the control of a conservator. And what do you know, in the recusal record on page 809 in 2009, when the surrogate helped Catherine Buck conclude the nursing home lawsuit in which he was representing her, what did he sign in the stipulation of discontinuance? A statement that she was not an infant or incompetent for whom a committee has been appointed. There was no basis to apply the Slade case, given that key fact that is in the record and that applies here. And all she needed to know was the general nature of her property. She did. The will should be enforced, the discovery petition should be denied, and there should be either a reversal or, at a minimum, if the recusal issue applies, all the proceedings should be vacated and there should be a new trial.
Thank you, Counsel.
May it please the court, Kevin Martin for beneficiary Michael Buck, who was also the fiduciary for the finances of Jonathan Buck. And I'm also arguing for beneficiaries Kim and Lisa Buck, who joined in our brief. Essentially, with respect to the recusal issue, as Judge Ogden asked, did Judge Gelati have any interest in this case? And the interest that we're talking about, if you read the case law that interprets that word, is that there has to be some sort of financial benefit to the judge. There has to be something that comes to him as a result of the litigation. It's not just some academic interest. It has to be some sort of financial interest or benefit. There was none. If you read Judiciary Law Section 14, there's only 4 very specific instances where the judge must recuse him or herself. In this case, none of those apply. You had to have been an attorney in the action. You had to have been a party in the action.
You had to have some knowledge about a disputed fact in the action that you're now deciding upon. None of that.
And you're saying even if he was an attorney for Catherine, it wasn't in this action?
Correct. He was representing Catherine in litigation brought by the Lutheran nursing home. And essentially, he tried to settle that case, and my client, Michael Buck, actually used his own funds and transmitted those funds to Mr. Gelati's law firm in order that the case be settled. So Mr. Gelati didn't review any document that came up during the estate trial. A check is not a document that a lawyer reviews.
Counsel, what about the argument that he represented Catherine at a critical time when ultimately his assessment is what was her capacity? And is he in a position to now be reflecting upon his direct knowledge of Catherine at a critical time?
Judge Whalen, it was not a critical time. It was several years prior to the signing of the will in this case. And it simply wasn't a critical time.
So your argument is it doesn't matter. If she had capacity then, for our purposes in this case, it just doesn't matter.
It's true that there was evidence in the record on appeal which showed that she was beginning to exhibit signs of difficulty and that there was a steady deterioration of her condition. However, the question, and the appellants in this case have pounded the desk very hard, that the issue is what was she able to understand on January 11th, 2011?
Isn't that the right question, though? Moving off of the recusal issue, isn't that exactly the right question?
It is.
What was her capacity at the time she signed this will? And we have testimony from, your opponent says, 3 different disinterested witnesses that say she knew what she was doing.
We would say that they're not disinterested. And we would say that they were all severely impeached. For example, Teddy Minutis had an attorney during the trial. I'm sorry, my mouth is... and that attorney was paid for by Rick and Stephen Buck.
Do you need some water, counsel?
I do need some.
Do we have some water, Ivory, maybe? You can help counsel with?
It was paid for by Rick and Stephen Buck. When Teddy Minuti was deposed in the case, she arrived to the deposition and it was discovered that in her lap, while she was being questioned, she had several pages of answers to our questions, which were given to her by Rick Buck. And she was a biased witness at that time. She was working not for Kay, she was working for the Buck Group. And her livelihood, she was dependent for her livelihood on Rick and Stephen.
Counsel and counsel's paralegal that witnessed the will, how are they interested?
Well, Peter Carl, to start with him, in addition to being impeached, he is interested in the sense that this challenge to the will that he drafted, and which really made no sense for Kay Buck, would be a blot on his reputation. So he was an interested witness in this case.
Is that an argument you can make in every case where you have an attorney?
I think so.
Witnessing a will and saying that everything was fine?
Yes,
Okay.
I think so. I think that he had a legal duty as her counselor to give her the best possible advice. And he didn't do that in this case. And he knows it. And that's why he testified as he did. As you read his testimony in the case, you're at a disadvantage here because you didn't get a chance to see him in the chair. But if you look at the insurance was mentioned, for example.
Ivory, thank you.
Thank you so much.
Insurance was mentioned. He was being cross-examined about the issue of the $1 million for the camp, which was very, very important to Kay. And he sort of speculated that she had insurance. And I remember asking him, did you review any insurance policies? No. Did you know if she had any insurance policies? Well, no, but I think she had some policies that were pledged to the Bank of Utica. And he kept, if you read that testimony, you can see that he's struggling and fighting to defend himself that, that this actually made sense. It didn't make any sense. She didn't have $1 million. She didn't have any insurance that could possibly cover that. And he mentioned that his father was an insurance salesman. That's how far he went to try to protect himself in the case. And if you review his testimony, he didn't know that she had a doctor. He didn't know that she had medical problems. He didn't know anything about her health situation. He claimed that he spoke to her every 2 or 3 weeks, but several witnesses testified that Kay never spoke on the phone ever.
Counsel, are you suggesting that a lawyer who is witnessing the execution of a will that they prepared for a client needs to know the medical history of the person before them? Isn't the interview for example, in the law office and questions being asked, isn't that what we normally do in a will execution? Lawyers don't ask clients to come in before they execute the will with their full medical record, right?
Well, he claimed that he spoke to her every 2 or 3 weeks. He testified without being prompted that she was a time bomb, a physical time bomb. So in cross-examining him on an issue that he raised himself, showing that he was claiming that he knew about her medical issues, when cross-examined, it turns out, no, he didn't. He knew nothing about it. And
what about the issue with the judge relative to the standard applied?
The correct standard was applied. So the things that are pointed to by the appellants in terms of the fact that there really was not $1 million.
What about the language I read just a few moments ago in the judge's decision referencing her not knowing the complexities of her property holdings? I mean, that isn't the standard, is it?
It's still admissible evidence in trying to show what her competence level was. So the judge never decided whether or not she understood in full her estate. But he's trying to figure out, was she competent? And what kinds of evidence can you bring to bear when you're challenging? Well, she signed this will that says there's $1 million for the camp. That was completely a fantasy. In addition to that, it made no sense for her to transfer RMBCC to Rick and Stephen from a tax perspective. Mr. Carl is a CPA. And there was testimony during the trial that, well, it would have been better if waited until she died and they'd get a stepped-up basis. There was no reason for her to do this. And none was explained by Mr. Carl on cross-examination. So bringing out those facts, that doesn't show the wrong standard was applied. It just shows that these pieces of evidence were used in determining what did she understand, how much competence did she have on the day, together with all of the other information that was brought out. Dr. Kanan's testimony was never testified, that he explained how she had, after her husband died, with whom she had 11 children and this extraordinary life, building up the RMBCC company, she became depressed. He died in 2007. She became depressed, and she slowly started to deteriorate. That's natural and understandable. And all that testimony, together with the fact that the will made no sense from the perspective of her assets, that brings you to the conclusion that she was not competent. And of course,
with respect to the transfer of the stock that you mentioned, I thought I had read in the record that there was a concern that she had about losing a family property because of the guarantee that she had signed. Is that something that wasn't appropriate? Was a fiction in her mind, or was that actually a concern?
She was concerned about the camp.
Right.
The camp meant a lot to her. I think there were several witnesses who mentioned that during their testimony. But the guarantee that she had given to the Bank of Utica for the debt of RMBCC was not being pursued. And Brian Laughlin came in and testified totally unrebutted. Their witness, the appellant's witness, was brought in, and he said clearly, we had decided not to pursue the debt. And what had happened was Rick and Stephen were going around telling everybody who would listen, including Peter Carl and Jim Gustafson, the CPA, the bank's going to foreclose on her. That was a lie. We brought in Brian Laughlin, who had contemporaneous records. He never spoke to Rick and Stephen about any foreclosure, and they weren't even trying to foreclose. And that was critically important in the case. Brian Laughlin came in and totally contradicted their entire theory as to why she needed to sign this will and as to why she needed to transfer the stock of RMBCC, which incredibly, the appellants in this case are saying, oh, that had no worth. It had no worth. Just several months after she transferred the stock in May of 2011, they refinanced 1 out of the 6 properties for $6 million, walked away from the closing with a check to themselves for $1.8 million. But it didn't have any value. That was just 1 out of the 6 properties. Several years later, they sold it for $25 million. Now, Mr. Buckeye claims that the record shows that some change in the law increased the value 25-fold. Not the case, not true. The cross-examination of the witnesses that were brought in on the HUD regulations completely debunked that. There's no evidence in the record which showed that some change in the law magically had everybody running out trying to buy these HUD properties. Not true.
Counsel, you should be mindful of your time.
Let me just make sure. With respect to the recusal in the case and the discretionary recusal, it would be a tragedy if Judge Gelati was recused. And you asked, when you were asking questions about when would it be appropriate for the attorneys to come forward and which attorneys would come forward. We submit that on our side of the table, we had no idea of any facts which would have caused Judge Gelati to even consider recusal. All of the knowledge of that representation was in the hands of the appellants. Judge Gelati is the only surrogate in Oneida County. When Don Gerace filed this petition, he knew full well that Judge Gelati was going to be the judge. He could, at that point, even before this case started, they could have said, you know what, we don't have to go down to Herkimer County because Mr. Gelati had represented the construction corporation back in 2007, 2008, before he was appointed a judge. They could have done it then. Then Judge Gelati sat on the bench during the 1404 hearings each day. And that was when he disclosed at the very beginning, while we were doing discovery in the case, that's when he disclosed that he had represented, RMBCC at the time in 2007, 2008. Everybody waived at that point. They could have had a jury trial if they were concerned about Judge Gelati's decision making. They waived that too. And then during the trial and during the motion for recusal in this case, all of the evidence that was brought forward was in their possession long before the trial in this case. My clients had no knowledge of any of this. It's simply not fair. They don't really have standing. If you're going to complain, you should do it sooner rather than later. We're not even in a position to complain.
Counsel, you should begin to wrap up.
I will wrap up right now. Thank you, Judge.
Thank you, Counsel.
Thank you.
Paul Steets from the law firm Steets, Reynolds, Steets & Jetgon, representing Joseph Timpano as a temporary administrator of the state of Catherine Buck. This appeal stems from a tragic case where 2 brothers from a family of 11 systematically planned and stole the business assets owned by their parents, converting those business assets into millions of dollars while their mother, suffering from Alzheimer's, was left to live in poverty without the most basic medical necessities. It shows the systematic plan was hatched in the years prior to 2011, in following their father's death in 27, memorialized in a letter from Stephen Buck to Brian Laughlin of the Bank of Utica, in which he outlined the steps that he and Rick were to take, which were to acquire the shares of RMBCC, further acquire the shares of Mary D. Buck Corporation, and then refinance Mary D. Buck for $6 million. This is a letter in 2010. He already knew the number he knew $6 million, due to the fact that they had in hand an appraisal done on the value of the Mary D. Buck underlying assets of a value of $5.945 million. And that showed up again in the refinance when the the same appraisal number showed up when it was done by the bank appraiser. And then they continued to take those steps. They misappropriated the mother's two share interests in RMBCC, the first one in January of 2011. They had on the record that it was for consideration that they were going to assume the debt of the Bank of Utica, which was never done. No consideration was ever given. They just simply took the shares of RMBCC into their own name, and then they did not cancel the mother's personal guarantee. Matter of fact, that personal guarantee was, according to the testimony of Bank of Utica Brian Laughlin, that personal guarantee was still in place on the date of death of Catherine Buck. They never assumed personal guarantee of that debt themselves, so they never assumed the debt. The debt just stayed in RMBC. All they did was transfer the shares to themselves. We also submit that those transfer of shares due to the fact that Catherine Buck had, as the judge found, did not have capacity to draw the will, that she would not have the higher standard of capacity to enter into a contract. The second share transfer in May of 2011 was done under the power of attorney granted to Richard Buck in 2008, again without consideration and not in her best interest. So I'll make the same argument with regard to consideration. They never paid, they never assumed the debt, and also that the transfer under the standard of Ferrara is that the power of attorney has to act in the best interest of the principal, and in no way, shape, or form do they do that. Mr. Martin talked about it, and I just talked about the value of that company, of RMBCC, their value in holding the general partnership interest in the 5 limited partnerships, and in particular the value of holding the 50% general partnership interest of Mary D. Buck, which, as we've just discussed, was valued by their appraiser at $5.9 million. Then they went on to move on to the Mary D. Buck shares in late, I believe, early 2012 by Amendment 4 of the partnership agreement. They transferred those shares to themselves, again without stated consideration of $1, which there's no proof was ever paid. But that was also a transfer under the power of attorney. The judge found that was improperly transferred, again, not in the best interest of the principal, who was suffering from dementia at that point. Moving on to the recusal matter. 3 steps. Section 14 of the Judiciary Law. Clearly, as Mr. Martin argued, none of the 4 elements of the Judiciary Law, the judge was not a party, he had no interest in the matter, he was not related to a party, and he did not appear as counsel or attorney in the case in the matter at hand.
I think we have that argument, counsel.
Pardon?
We have that argument, counsel. Anything
Yes.
further?
No, I'll go on with the waiver issue. Mr. Buckeye brings the fact that there were general partnership interests owned by Catherine Buck in the 5 limited partnerships at the time of her death. Those general partnership interests were reiterated in a 2016 amended and restated partnership agreement for each of the 5 limited partnerships. And those partnerships gave substantial benefits to her during her lifetime, as well as her estate, and more particularly on the sale of the underlying assets of the partnership, which occurred in December of that year, and with the fact that those general partnership interests were ignored upon distribution. Mr. Buckeye argues that there was a waiver. The waiver has to be knowing, intentional, and there's no way she could have. She was in severe dementia at that point in her life. The underlying partnership agreements were signed on her behalf by Richard Buck as power of attorney, and in no way, shape, or form could she have possibly waived those interests.
Very good. Thank you, counsel.
Thank you, John.
Case 807 and 808. Pretty Pritchard versus Hargis. Proceed, counsel.
Good morning. If it pleases the court, Rebecca Cons on behalf of the father. As an initial matter, I'd just like to clarify, there's some discussion about the father failing to appeal the February 2019 order. In May of this year, there was a hearing before Justice McCluskey, and a settlement was reached that found that the father's attorney did commit malpractice by not filing a notice of appeal, and the father was granted $2,000 in damages. And if you would like the transcript of that, we can provide it upon request. The family court erred in finding the father in contempt in this matter, as the aunt lacked standing under domestic relations law to seek visitation of the child. At the time that that was issued, the father had sole custody. Going forward, the standard of care, the standard that they had to meet was extraordinary circumstances to remove custody from a parent and give it to a non-parent. The temporary order.
And the prior order, it was established, right?
It was established.
Extraordinary circumstances was established. The one you were referring to, that there was some malpractice, apparently, that's outside the record before us, though.
Yeah, it is.
Yeah, okay.
The temporary order was issued ex parte that granted the aunt temporary custody because the father wasn't provided an evidentiary hearing.
So the issue is that the aunt is seeking custody.
Correct.
And then the first thing the court has to do is make a determination as to whether there's exigent circumstances, which the court did back in February before making the determinations as to custody. And what you're claiming is that that determination of exigent circumstances, that had to be redone.
Correct.
Because in addition to seeking custody, the aunt did not specifically seek visitation as an alternative.
Correct.
But was awarded visitation in that February order. So that because of that, the aunt then, 2 years later, needed to establish exigent circumstances a second time.
Correct.
Okay. The authority cited by the aunt, the matter of Van Dyke, matter of Gwinta, and there's a couple of other cases as well. It doesn't look like you addressed those cases in your brief.
Most of the cases addressed by the aunt are between a parent and a parent. They don't have a lot that address a non-parent with a parent. I know why we refuted some of the ones because the circumstances are different in this one because it's a non-parent, it's an aunt. It's not even an adoptive parent, it's an aunt. The father had sole custody in this case.
Right, but matter of Van Dyke, the quote given, 4th Department, 2014, once a court makes a finding that extraordinary circumstances exist, that issue cannot be revisited in a subsequent proceeding seeking to modify custody. So why should we ignore that? Again, not addressed in your reply brief.
Because in this case, the father had sole custody and she didn't prove anything beyond that he moved to North Carolina.
But you would agree that if the extraordinary circumstances had been redone again for a second time, that would resolve the issue of standing. So really, the only issue with standing is the fact that we didn't go through or that the court didn't go through and try to find extraordinary circumstances a second time.
Correct. And that the temporary order that gave her the custody and allowed her to go down and remove the child was done against the father's rights. He wasn't given an evidentiary hearing.
And that order wasn't appealed.
That order wasn't appealed either, which might snowball into the whole, malpractice issue. I'm not certain about that one, whether he asked for her to appeal the temporary order or not.
Was that part of the malpractice claim, or was it the first
It wasn't. It was the first order. I'm just saying that it might fall under the same umbrella that, if she failed to do it once, she failed to do it again. If you go and you read Judge Swersman's February 2019 order, you can get a picture of the situation in this case. He talks about how the animosity that the aunt has towards the father was palpable, and that she was doing things in her own right to deny the father access and to his child. The timeline, it looks a little bit worse than it is. He actually was granted joint custody back in July of 2016, and then he was given full custody back in 2019. So he was working towards, the length of time isn't necessarily his fault. The court system took a while with the case with the mother. Another big issue in this is there's no set visitation schedule, and that is a huge flaw in this order. It just said as the parties can agree, and that's not giving the father meaningful time to establish a relationship and to maintain that relationship with his child. It says telephonic communications up to 30 minutes. They're averaging about 2 to 5 minutes right now. That's when he can actually get through, or the child's doing other things. So the aunt is not really facilitating the relationship between the father and the child.
Doesn't the record reflect that the aunt tried to offer the father opportunities for visitation in New York State, but the father didn't want to come up because he's worried about the contempt
Yep,
finding?
the contempt
and
finding
7 days.
is a big deal. And also, there were some other supposed offers that look really good on paper, but when you come down to the details, it was requiring the father to drop everything at a moment's notice and drive 8 hours to see the child. That's not really meaningful visitation.
So otherwise, the father's claim is that because he was in contempt and had a finding of contempt and is subject to the 7-day in jail suspended sentence, because of that, the aunt should then take the child physically out of New York State and facilitate access with the father in some other state, North Carolina or some other state. The aunt should now be incumbent upon the aunt to do that because the father was in contempt.
I think there needs to be a set schedule so that there's a way for the father to have visitation without.
Wouldn't there be an opportunity if in fact there's not, access is being limited right now, that you could go back in and reapply and say, look at the circumstances, we're not getting the up to 30 minutes we were supposed to be getting, and judge, because of this circumstance, it's been changed, we need to have the court review this? Isn't that available to the father?
It is available to him, and I'm uncertain whether he's.
Okay. Anything further, Counsel?
Just to reiterate that, the aunt is willing to do whatever she has to in order to get custody back. She went and she lied about the imminent danger to the child in order to get the child back from North Carolina, and that the standing is definitely an issue.
We'll take a look at it, Counsel.
Thank you.
Good morning, Donald White, excuse me, for the aunt, Victoria Pretty Pitcher. At the outset, I'm not sure what relevance it is about this malpractice action and a $2,000 award.
It's not part of the record before us.
It's not part of the record, and the fact of the matter is, for whatever reason, Father never appealed the February 2019 order.
So your argument is they don't have to revisit extraordinary circumstances in this case because it's already been established?
Correct. As Justice Nowak pointed out, it's governed by the matter of Ginta versus Doxeter case and the cases that followed that once a court makes a finding that extraordinary circumstances exist, the action can't be revisited in a subsequent modification proceeding. This was a custody modification proceeding, so the standard is, was there a change of circumstances that rises to the level that the custody arrangement should be relooked at to ensure the best interests of the child? And that's exactly what family court did. Clearly, there were changes of circumstances. Father just ups and absconds with the child to North Carolina. Basically says that aunt and mother are never going to see the child again, withheld visitation to the aunt on numerous occasions. That clearly is the change of circumstances. And then the court's best interest analysis, in my view, was spot on. That clearly the aunt at this point in time is the more fit parent. And whatever the circumstances were back in 2019 with the prior order and decision, that's irrelevant to a modification of custody proceeding. The issue is, well, what has changed and what are the best interests now, subsequent to that order? So whatever the court put in its original decision really doesn't matter in this case.
Should we be concerned that the current order may not give the father any access at all?
Well, the current order does give him access. I guess we'll hear from the attorney for the child. I don't believe the father has made any effort to come up to New York to visit the child. You know, that he can have supervised visitation with the aunt. She did it with him for years, supervised his visitation, and he's made absolutely no effort to come and see the child. And again, as Your Honor pointed out, it's not incumbent on the aunt to facilitate dad's visitation. He's got to do something on his own. He decided to move to North Carolina. And in fact, the record shows he was making more money in Watertown at the same company at the Watertown plant, but he decided to move on the speculation that he was going to lose his job. And as Justice Whalen pointed out, the father is not precluded from going back to family court. And if there's a change of circumstances, ask for other visitation. Right now, we don't even know if supervised visitation isn't working because he hasn't tried to exercise it at all.
I think we have your argument, counsel. Thank you.
Thank you.
Counsel Wood? You're on mute. You need to unmute your computer.
May it please the court, I am Kimberly Wood, attorney
Counsel,
for the
before
child, Liliana.
before you get going, can you hear us well?
I can hear you just fine, Judge.
And we can hear you. Please proceed.
Thank you. May it please the court, I am Kimberly Wood, attorney for the child Liliana Hargis. She's currently 11 years old. I'd like to address a couple of things that were raised. There have been further proceedings in family court since Judge Nelson's order was issued. After the malpractice matter was heard in Supreme Court in May 2023, the father immediately filed in family court. The father immediately filed in family court a writ of habeas corpus, or an application for a writ of habeas corpus. That was denied. There were proceedings then held for another writ of habeas corpus in Supreme Court in or about July 2023. There were violation petitions pending, and a hearing was held in August 2023 with regard to those petitions. So there have been proceedings that have taken place while this appeal was pending. The father is not visited with my client in person in 2 years. Although he was present in Jefferson County in May 2023 for the malpractice proceeding held in Supreme Court, he did not exercise any time with Liliana while he was here then. In August 2023, we were having a trial in Jefferson County. However, he did not come to this county. He was invited to celebrate Liliana's birthday party with her. I would note that basically her birthday parties include other family members, Mr. Hargis's children, grandchildren, etc. I believe that Judge Nelson's order really examined and made certain findings of fact that were important in this case. She went through all the factors. She put extra weight on like 3 factors. One, that the father continuously stated over and over and over that he was not going to follow any directive or order of the Jefferson County Family Court. He kept arguing throughout the years that the family court did not have jurisdiction to make that order. Now, that's the order that gave him custody of Liliana. And the malpractice action was against the attorney who represented him when he regained custody of Liliana for the first time since she was born. He was happy at that moment. He did not wish to appeal. If he did, he's exercised many rights to appeal in the past. He's represented himself in many different court proceedings. He's we've had different appeals in the past. He represented himself in connection with the Supreme Court writ of habeas corpus proceeding. I'm not saying that he shouldn't represent himself. I'm just saying that blaming his attorney for things from 2019 seems a little bit ridiculous to me. Liliana's best interest would require that the order was modified from custody to her father. Mr. Hargis,
Counsel, you're asking this court to affirm the lower court's order?
I certainly am, Your Honor, please.
Thank you, counsel. We're going to take case 810 out of order. Cedrone versus City of Fulton Assessor's Office. Counsel, my understanding is the pro se appellant has submitted in this case?
Yes, Your Honor.
Proceed.
So, may it please the court, Nick Cortez on behalf of the City of Fulton. I just want to raise a couple of brief points with respect to the vacant parcel. This was the one that the SCAR hearing officer had disqualified as being ineligible for SCAR. Of course, because the petitioner is pro se, we tried to construe his petition liberally and interpret it such that he could maintain both challenges in court. As you're aware from the record and from case law, when a vacant parcel is brought to a SCAR proceeding, unless that vacant parcel has been determined by the assessing unit to be too small to have an improvement constructed upon it, if the vacant parcel is residential. The only remedy, statutorily speaking, is to bring a traditional Article 7 proceeding under the real property tax law, a traditional tax cert proceeding. So with that being the case, we construed it that way, though the petitioner has said in his papers and in the record that he only intended to bring an Article 78 proceeding and didn't intend to bring an Article 7 proceeding. So if you take petitioner's word for it, the challenge with respect to the SCAR hearing officer's disqualification of the vacant parcel should be dismissed out of hand. If you take a look at it as an Article 7 proceeding, however, there are multiple service errors under RPTL Section 708, and this court has expressly held that in a situation where the superintendent of a school district is not properly served, and in this instance, the record shows that the only person from the school district that was served was the school district clerk. Additionally, we, the city, were not personally served. The correct city official was not personally served. As far as we know, only the mayor was served by certified mail. With those errors being the case, even if this was properly asserted as an Article 7 proceeding with respect to the vacant parcel, it would have to be dismissed anyway because the only excuse for errors in service, even despite the fact that this is a pro se petitioner, is for good cause shown, but because of the strictness with which this particular service statute is interpreted by the courts, good cause does not include an excuse that I tried really hard, but I just don't know what the law is, and so I made a mistake. And so while I understand the situation, the law is what the law is. And so with respect to the vacant parcel, whether or not it's valid to have been considered by Supreme Court, it should be dismissed for service errors. Additionally, I do just want to point out with respect to something that the petitioner said in his reply brief, he's making much of the fact that the property is landlocked and it can't be built upon. And as a result, maybe the SCAR hearing officer should have ruled on the merits. However, I checked GIS just last night to make sure of this. It is not a landlocked parcel. So the argument that he's built, it starts with the foundation is, my parcel's landlocked, I can't build anything on it. But in fact, it's a 1.7 acre lot that's a flag lot, and it does have somewhere between like 32 and 35 feet of road frontage. So it is unquestionably a buildable lot. With respect to the improved parcel that was ruled on the merits by the SCAR hearing officer and was the subject of the Article 78 proceeding, I won't belabor the court with the factual details. That's all in my papers. I would just say, though, that this court has previously held that in a situation where a municipality produces valid comparable sales at a SCAR hearing, and the SCAR hearing officer relies on those sales, that gives a rational basis to the SCAR hearing officer's decision. We would submit that we did submit valid comparable sales with homes that were exactly like Mr. Cedrone's home.
So that's the rational basis, and that's all you need to do, is your argument?
Yes, Your Honor. If you produce comparable sales and that are valid insofar as they are fairly recent sales within, roughly a year, as close as possible to the valuation date of the real property, and they're similar in character, and appropriate details are taken into account with respect to the quality of one property versus another, all of which were done here. That's all in the record. I would say that the SCAR hearing officer had an ample basis, regardless of the voluminous explanations that the petitioner gave with respect to the substantiation of his own valuation. When you boil his argument down to what it is at its essence, it's that my evidence is better than the city's evidence, and you should credit my evidence and not the city's evidence. But as we know, that's not how an Article 78 works.
Thank you, Counsel.
Thank you.
Case 811, Jaysmain versus Time Cap Development et al. Find a seat. That's all right. Counsel, proceed.
Good morning, Your Honors. Virtually every party here is an appellant and a respondent.
Right.
Is there some order the court would prefer to hear the arguments in?
Nope, you can proceed.
I will proceed then, Your Honor. Stephen DeVoli from the Sugarman.
Understanding, Counsel, that the positions you take, because of the circumstances here, you are to make all your arguments when you're at the podium. There's not going to be a recalling and coming back.
Correct, and that was my assumption. Thank you, Your Honor.
Very good, thank you.
Stephen DeVoli from the Sugarman Law Firm. I represent Defendant Time Cap and Defendant 980 James. Defendant Time Cap is the general contractor, 980 James is owner. I will quickly tick through the various motions for the court. The court granted our motion for indemnification against the employer, Syracuse Energy Systems. We're urging the court to affirm that. The provision required only that the indemnification arise out of the work, not that the employer be negligent. It's a very broad provision, and the argument on the employer's side was that the circumstances didn't arise out of the work because the employee was moving somebody else's equipment. We think that's completely contrary to this court's understanding of what engaging in work is, and we would urge the court to affirm because that argument has no merit based on a plethora of case law around construction sites. One other argument that was made was that ultimately the indemnification provision shouldn't apply because it's possible that Time Cap could have some negligence in the case, but as this court's well aware, partial indemnification language is allowed, and to the extent that partial indemnification would apply, that would not invalidate the indemnification provision. In the event that one of the defendants could not pay a judgment, we would still be entitled to indemnification from the employer. So there are academic distinctions. Even though the employer may not be found culpable in the case, as the general contractor, if there was co-liability and a co-defendant couldn't pay, we would still be entitled to that indemnification. So we would urge the court to affirm for those reasons. We opposed Interior Builder, the co-defendant's motion for summary judgment. We're urging the court to affirm the court's decision denying their motion. Our only real points on that, Your Honor, is the potential liability against Interior Builders is the same theory against Time Cap, one of the theories, and that is that this drywall was stored in a way that was unsafe. Our position is that it was not stored unsafe, and I acknowledge that if the court found that there would be no basis for liability against Interior Builders. If that is the case, we would urge the court that that theory of liability also has to be dismissed against Time Cap as well. In the event that the court finds a question of fact or affirms that there's a question of fact on the storage of that material, our only position would be then obviously both Interior Builders and Time Cap would remain in the case. Just that that be applied consistently. Moving ahead quickly to the main action between the plaintiff and the
Let me just stop you
defendants.
there, counsel, so I understand your argument, because I get a little confused with the back and forth.
It's not just you.
Okay,
There's a lot
thank you.
going on here.
But, so, in the event, just assuming arguendo that the court were to find a question of fact on the 241 sub 6, you're then saying that you are entitled to indemnification against other parties?
In the event, well, certainly, so
I thought that's what you just said, but it may have.
Yeah, I'm skipping over a lot because I know there's a lot to talk about, but I'm going to slow down since you've asked a question. So the court dismissed 240 and 241-6. Those are statutory liability questions. The ultimate question is going to be whether there's culpability, active culpability, right? Because when there's passive liability, you're certainly entitled to indemnification. The question in this case is whether my client, TimeCap, has active culpability. The general obligations law does not allow someone to be indemnified for their own culpability, and we acknowledge that. So all we're saying is if there's any liability...
And the supervisor was one of your clients?
The
person on the scene? Hegel, whatever the name is?
Yeah, he was an employee of the general contractor. He wasn't the plaintiff's supervisor.
Right, I know that, but one of your client's employees?
Yes, one of my clients was on the scene and assisted the plaintiff with moving this drywall. We are on the scene, yes.
So if a court were to find a question of fact on the 241 sub 6, you don't get indemnification because there's a potential that your employee was negligent, right?
Almost. I would say only to the extent we would be entitled to indemnification to the extent and percentage we did not cause the accident.
But we can't figure that out on this record.
Correct.
That would be someday.
And that's my argument for affirming our entitlement to indemnification. The extent of the indemnification is still subject to trial. But this order grants us defense, first and foremost, which is, I don't believe, in dispute, and indemnification to the extent the law allows it to be determined by a jury. And so that's our position. Thank you for that. And moving into those questions about the plaintiff's main action, my first very, I believe, easy point is I represent two clients. One of them is the owner. The court found that there were questions of fact about how the drywall was stored and the manner in which it was moved. I think the court simply just missed the fact that those questions don't apply to the owner. It's clear the owner was not on site, delegated all responsibility, had no control over the site, and the court simply should have dismissed that defendant out of the case on a negligence basis. And the other causes of action are obviously statutory. Assuming the court affirms those bases, the owner would not be in the case at all. The statutory bases are what they are. If the court reversed, then obviously the owner would still be in the case. But we believe that's frankly an easy reversal because it was just missed. The distinction was missed by the court between the two clients.
And that's on the common law of the 200?
Correct, right, because the owner has, of course, statutory obligations if those did apply. Moving on to those, under Labor Law 240, we think the court should be affirmed. We think it's pretty clear. It's sort of like you know it when you see it a little bit, but we've got drywall.
You're saying 240 sub 1, you know it when you see it?
Yeah.
Okay.
Let me phrase it better. I know when I don't see it, and I don't see it here. That's probably a better way to phrase it, Your Honor.
Well, I have some questions on that. You go back to Runner, and then Walensky. Walensky was what? A 4-foot fall of a 10-foot pole, right? Because they measured the height of the plaintiff, right? But this is, if I understood the expert's testimony in the record, these were 12 sheetrocks.
4x12s.
4x12, and 12 of those fell on the plaintiff's ankle.
Right, but...
And the weight of them combined, as I understand the undisputed record, is approximately 1,200 to 1,300 pounds.
Right.
So the weight is severe.
Oh, there's
the
no...
distance is roughly 4 feet.
Correct, because they were in the long position on the floor.
I saw the picture.
Okay.
So, and do I have it right that there's 12, and they amount to about 90 pounds each? So
I believe that's
roughly
about correct.
1,200 some pounds.
It was very significant.
That's the force of gravity that's falling.
That's where I would take issue, Your Honor.
But isn't that a question of fact?
No, not on Labor Law 240, no. And this is the key distinction, I think, what's been missed. The plaintiff made 2 points, that this material should have been braced and prevented from falling. Well, if this case was the type of case I think you're thinking of, Your Honor, which is where this material somehow became dislodged and fell on the plaintiff, there might be a better argument that Labor Law 240 would apply, but that's not what happened here. We have material that was leaning against the wall in a perfectly safe condition, and then the plaintiff and another employee of ours engaged in the act of moving it.
Isn't that a question of fact, whether it was in a perfectly safe condition? I mean, the premise of your second part of that argument, I understand. But a perfectly safe condition might have been laying flat on the ground, not leaning against a wall, blocking a door.
Well, if it was laying flat on the ground, it would create more of a hazard and be more of an obstacle. And I understand the counter to that isn't that a question of fact? Here's why I don't think it is, Your Honor. Because at the end of the day, the position it's stored in, the court or a jury could potentially find that to be negligent. Let's just concede that for the purposes of my argument. But once the plaintiff and his coworker take it out of the stored position and start to move it by hand, the stored position is no longer relevant to the equation. They're now moving.
So you're saying it falls under common law negligence or 200 possibly, but under 240(1) it doesn't fall under that?
I think the same argument applies to the negligence argument. I think it's a lack of causation, a lack of connection. You can't brace it because they're engaged in moving it. This did not fall. Nobody bumped it and it fell. It frustrates the purpose to brace it. They're actually trying to move it. So you couldn't possibly brace something you're trying to move.
Let me give you an example, if I can. Just let me give you an example. 30-foot ladder, Stanley, heavy-duty ladder kind of thing, leaning against the wall. And due to some vibrations in the building, falls against the worker. Is that the same as here?
No.
Why not?
Because the force that caused the drywall to tip over was the force applied by the people. It wasn't inadvertent. It was intentional.
But isn't that a proximate cause argument you're making?
Yes.
And isn't proximate cause quintessentially a question of fact?
If you look at the cases I cited, Your Honor, this is a furnishing occasion of the accident type of causation. Once the intent of the party, the actual intent is to take it from the stored position, successfully move it into a different position.
I wouldn't say successfully.
Well, I mean, at first it was successful, but it was the intent of the party to take it from the stored position. They succeeded in doing that. They stood it upright. And now they're engaged in the act of moving it. The manner in which it was stored has now been rendered totally irrelevant.
But when the materials are blocking a doorway, why isn't it reasonably foreseeable that someone's going to be moving it? Someone's going to necessarily have to move it.
You're touching on, well, this is why I don't think that matters, Your Honor, because drywall that's being stored around a job site has to be moved for a myriad of reasons. And this gets to the heart of Plaintiff's argument is the fact that it had to be moved at all is the defect. Well, the drywall could have been stored 6 inches to the right, let's just say, and not sticking out into the doorway a little bit. Someone's still going to have to move that drywall. Moving the drywall is not a defective condition. The fact that it has to be moved, that did not cause the accident. It caused the reason someone had to move it, but that reason is not a defect.
What about the fact that there's a safety device that may be available to safely move it, and that's not present here at the site? There's not a drywall dolly that can be easily used to move it safely.
To me, Your Honor, respectfully, I think that's an easy one. A drywall dolly is not a safety device enumerated by the statute. It's not even close. I mean, but that does go back to my point about the argument about the bracing. You can't use a device to hold something in place you're trying to move. So I think the devices argument simply doesn't apply, and I've made that point.
But isn't that a question of fact for the jury? I mean, the plaintiff cites the Flowers case, which relies on our case, Floyd, and we've since cited it, I think, in Vicky, whatever the name of the case is. But this is a falling object case, right?
I don't believe so, no.
Well, it's not a falling worker case, so therefore it's a falling object.
To the extent it's one of the two, I understand, yes.
You know, and by the way, I'm not asking
which category does it belong in, Your Honor? Yes, I believe that's the analysis we're in.
So we said that in those type of cases, a plaintiff must establish both that the object was being hoisted or secured, or that it required securing for the purposes of the undertaking, and 2, that the object fell because of the absence or inadequacy of a safety device to guard against a risk involving the application of the force of gravity over a physically significant elevation differential. As I understand the argument by the plaintiff on appeal, they're not looking for partial summary judgment anymore. They're simply saying those two elements have a question of fact. That is, theoretically, was it being hoisted? Maybe. And I'm not making the argument, I'm just saying this is, I'm giving you a chance to respond, so you're not surprised with the questions I might have for the other side. And then, that is the dolly, if it had been available, could that have been a safety device? You say it's not. Is that as a matter of law? Where do you have that as a matter of law? I'm not sure.
Well, I would say absolutely, Your Honor. I think the statute enumerates types of devices, and I think it's clear that a drywall dolly does not fit either as a matter of law into the language of the examples given in the statute, or I think, again, practically, let's just say that there was a drywall dolly on site, and I know it's, the underlying court doesn't want to engage in fact questions, but I do think that as a matter of law, we can engage in some amount of reasonable analysis of facts. Let's just say there's a drywall dolly on site. What has to happen? That drywall has to be picked up and loaded on a drywall dolly. The act that occurred still has to occur. If you want to move drywall 6 inches to one side, it all has to be picked up and set on that drywall dolly.
Well, aren't those completely different acts? Picking up, say, a piece of drywall and putting it on a dolly versus tipping the drywall off of the wall?
They are. There's certainly two different ways to go about it, and my whole point, Your Honor, is not that necessarily one's better than the other, but that it's simply not, it's required. It's not required. There are many instances on a job site where some things are better than others. I'm not sure the drywall dolly here is, but things can be better than others without being negligent or a statutory violation. There is room for things that meet the standard but are steps better than others, and that's the area I think we're in, Your Honor, is this is simply not a labor law 240 case. We have an object on the floor, leaning against the wall, never came out of contact with the floor. The plaintiff...
that makes no difference, counsel. I mean, that might be where the court, in its analysis, may have got something wrong. I mean, being on the same level doesn't matter.
Not necessarily. I agree with that.
Not just not necessarily. The Court of Appeals has been quite clear. I mean, I'm looking at a case in the First Department. There's a fire pump that's 400 to 500 pounds. It's left in the middle. It's kind of unstable, and it falls over and hits the plaintiff's leg. It's not one of our cases. It's in the First Department. And that was partial summary judgment for the plaintiff, and where it fell over on his leg. So,
but again, and again, perhaps this distinction, I feel that this is a very important distinction. This did not fall. This was pushed over. It was the intent of the parties to move it. I think that is a big distinction under this analysis. These parties intended to move it.
We'll take a look at that. We've gone over that.
Okay.
You want to move on?
Yes, I think we touched on Labor Law 241.6, so I won't belabor it, but I just want to hit the outline of my points.
there's clearly a violation because it's blocking the passageway.
Well,
Whether it's approximate cause of any injury might be a separate question, but it's definitely blocking a passageway.
It's blocking a few inches of an otherwise large passageway. I mean, it's not blocking anybody from walking in or out of there. I would argue...
testimony was saying 40 to 50%, and in this motion, in this context, we have to take that as true.
If somebody said 40 to 50%, I take you at your word, Your Honor, that that's in the record. It's never been, I don't recall discussing it in that way with a witness, but I'll assume that you're correct, because at the end of the day, to me, it's a distinction without a difference, because we had a passageway that people could safely walk in and out of in either condition. The issue is that the scaffold or device couldn't fit through the door, and to me, Your Honor, that's an inconvenience. That's not a safety hazard. Imagine a scenario where it's almost the same, where instead of this drywall blocking the doorway, you had a nail gun in the way, and you couldn't roll through it. You bend over, you pick up the nail gun, and as you're moving it, you drop it on your foot and get injured. Is that a Labor Law 241.6 violation because the nail gun started in the passageway? That doesn't make any sense. That's totally disconnected from why the accident happened. And that's what I'm trying to get across here with Labor Law 241.6. Yes, it was moved because it was obstructing a passageway to some extent that you could, there's some question of fact on at least the extent, but there's no question of fact that the device couldn't fit through there. That gave rise to why it was moved, but ultimately the fact that it blocked the passageway was not the cause of why the accident happened. So I think that I've made that point, and I'm not going to take any more of the court's time with it. I think that some of the cases cited by the plaintiff, I don't think there's any expansion by the court here needed. Some of the cases talk about, I think the plaintiff said, well, there are cases where something didn't have to occur in a passageway. I think that, as I explained in my brief, the court interprets the passageway to mean the entrance, the exit. I mean, it's a broad definition of passageway. So the court in some of these cases is not expanding that, the regulations saying they don't have to occur in a passageway. The courts in those cases are saying the passageway includes the area in front of it, itself, the area around it, anything that would obstruct your access to it. So I don't think there's an expansion of the cases there. Finally, on the issue that we are an appellant on, and a respondent, I guess. On the issue of negligence, my argument, the court found two issues of fact: how it was moved and how it was stored. Right? Those are the two issues of fact. Our argument is simply that, again, if at the end of the day, the way it was stacked does not constitute a cause of this accident, because the way it was stacked was rendered complete. It was no longer being stacked anymore when they moved it. So that's why we don't think that matters at all. Same thing with the manner in which it was moved. The only way to move drywall is by hand. Whether it's stored on the ground, it has to be tipped up. And when you tip it up, it can fall. I think that we're dangerously getting to a point where we say anytime a worker is handling something and it falls or in some ways injures him, that can somehow constitute negligence. I think ultimately, what we have here is two people moving materials by hand. That material, they lost control of it, and that's what caused the accident. Not everything that ends up injuring somebody is a result of negligence. And so I believe that's the gist of our arguments. We don't think direction and control matters because at the end of the day, that's just the duty element. The main crux of my argument here is there's just no negligent act.
Thank you, Counsel.
Thank you, Your Honors.
Do you have a preference?
I don't, Counsel. If you've decided how you want to go, I'm fine with that.
We did not, but I was closest, so I'll start.
There you go, that works.
Good morning, Your Honors, and may it please the Court. Kelsey Shannon from the Lynn Law Firm for the plaintiff, Connor Jesmain. With your indulgence, I may start where Mr. DeVoli ended, which is, I think, an argument that cuts across many of the issues in this case, which is fundamentally proximate cause. And I heard him saying in connection with the 200, well, this was not, two people were moving this, and that shouldn't be sufficient. And I think here, as in so much else, what they are asking the court to do is to usurp the role of the fact finder and make a determination on proximate cause. And, as the court is aware, and as Your Honor, Justice Whalen said, that's generally for the fact finder. There is a very narrow exception to that for instances in which the negligence merely furnished the occasion for the accident. And this argument, particularly this court's decision in Hurlbut, is all over the papers, both of interior builders and of time cap here. That narrow exception is defined by the Court of Appeals decision in Hain, which came out a year after this court's decision in Hurlbut. Hain actually came from this court as well, Your Honor, Justice Whalen, you dissented below, where the court had applied Hurlbut to dismiss a claim, and the Court of Appeals said, as it should, proximate cause is an issue for the fact finder. There's a very narrow exception. What we are going to look at to apply this furnace the occasion exception is foreseeability and is the negligence of the type that foreseeably causes this type of injury. There's no cow that walked out onto the work site here, right? The sheetrock was left unsafely. The sheetrock fell and hurt the plaintiff. It doesn't take a great leap to get between those two. I'll move now briefly to the different causes of action. On the 200 claim and the negligence claim, I don't dispute that there's really not a 200 claim against the property owner, and that probably should properly be dismissed. There is obviously, if there is a 240 and a 241-6 claim, those would lie against the property owner because that's not a delegable duty. In the papers on the 200 case, their defendant cites very little case law, and I think there's good reason for that. We have a unique situation on the 200 claim in that the general contractor supervisor on the site is directly involved in the injury producing activity. Both he and the plaintiff agree that he's the one who told Mr. Jesmain how to move the sheetrock that ultimately fell on Mr. Jesmain. It's very difficult for me to see how there is not, at a minimum, an issue of a question of fact vis-a-vis time cap given that dynamic. Moving to the 240 claim, I think as we look through the case law, what you derive in these falling objects claims is the court is looking for three things. The courts are looking for three things. They're asking, is this an injury that was caused by the exercise of gravity? That's a simple one here. There's no real dispute about that. They're looking at, is this a physically significant elevation difference?
Or is it de minimis?
Or is it de minimis? And I think that's where most of the dispute lies here between the two sides. And I agree. I don't think there's any question that there's a de minimis exception to that rule. I think here, where we have, according to our expert, 1,260 pounds of sheetrock falling 4 feet, that's not de minimis. Justice Curran, as you point out in Runner, what the court said, what the Court of Appeals said, is we look to the weight of the object and the amount of the force that it is capable of generating. Here, as even Mr. Davoli, I think, conceded at one point, there was a lot of force that fell on Mr. Jesmane's leg. Is there a question of fact? And Justice Curran, you suggested earlier, maybe plaintiff is walking away from the request for summary judgment. I don't know that I'm formally doing that, but I do think if you read the case law, particularly as it has developed, in the 4 years since this case was filed, maybe there's probably a question of fact on this issue, and then
Well, it's difficult in a way. I mean, in a perfect world, we would have perfect consistency.
Right, Your Honor.
This area of the law is definitely not a perfect world, right? But so there's our Miles case, I think that's the name of the case from 2014. There's the Wiley case, I think from the 3rd Department. But some of those cases seem to even tie in the same level concept, at least in some of the description. But for the most part, as I understand, the Court of Appeals has completely moved away from that. So, it used to be, we used to think, at least I did, a falling object has got to fall from above the plaintiff.
Right.
That's no longer true.
Right.
And now we look at the weight of the item and how far it fell. Is 1 foot, 2 foot, 3 foot, 4 foot? I mean, I can give you a case from our court where it was 1 foot and a 68-pound pipe fell on the plaintiff's shoulder. That wasn't enough. That was de minimis. And then, you've got the 4-foot runner case, things like that hits the person on the head.
Right.
So I don't think it matters that if it's above the head. It's so often about the significant elevation is also having to do with how much weight fell.
Right, and I think to
Can you
your...
give me an answer?
I don't have one. I guess what we're all trying to do is synthesize a lot of case law that doesn't always point in the same direction, correct? And over a extended period of time. One case, Your Honor, didn't mention and that's cited in our papers is Padilla versus Toro College, which is a 2022 decision from the First Department, which looks very similar to this case. If anything, I think the facts are less favorable to the plaintiff, and the court in that case found that there was a question of fact there. I think obviously Walensky precludes a same level defense. I think the defendant certainly acknowledges that, at least technically, but I think tries to backdoor create a different version of a same level defense by emphasizing whether the item tipped or fell on the person. I do acknowledge that those are two different words, but I'm not sure there's an operational meaning difference between those two. And certainly in Walensky itself, to the extent the question is, did it tip because it was in contact with the ground, or did it fall? In Walensky, the pipes that fell on the plaintiff were on the ground. They weren't above or they weren't elevated in any way from the ground. So I don't think that can be the rule either. And so I guess, Your Honor, Justice Curran, I come to maybe where you're implying we should be is, these are difficult questions. The case law perhaps does not provide a definitive answer to what constitutes a physically significant elevation difference, and given that, perhaps that is a question for the jury to ultimately make a determination of, is this a physically significant elevation difference? Yes, Your Honor.
By the way, Padilla relies on a case called Kylen, K-U-Y-L-E-N, which is where a worker walks into a room and all of a sudden 25 to 30 sheetrock boards falls against it. It was leaning against the wall. And they found questions of fact with respect to whether the plaintiff's injuries flowed directly from the application of force of gravity, whether the elevation differential was de minimis. All this was questions of fact for the jury. At least in that case. Now, that's the First Department. I don't know if we have cases that say that.
And Your Honor, I just very briefly on the Third Department cases, Wiley and Oakes, we discuss in the brief the reasons I think those are distinguishable. On the other hand, I think you could read those cases and see them as applying something very close to a same level defense. I suggest that's inconsistent both with what the Fourth Department has held and what the Court of Appeals has directed us all to do. My last point on the 240 is the safety devices. From my position, I think the question of safety devices is essentially unrebutted. We submitted expert disclosure. They didn't put any experts in on summary judgment. The argument that I hear being made is something like they couldn't have used the safety device anyway, and that may or may not be true, but what that's saying is the way that this was stored on the worksite was so unsafe that there was no way to use the safety device to address that, and I think that proves too much and creates, again, an exception to the 240 law on the safety devices that shouldn't be permitted.
Any further, counsel?
No, Your Honor.
Thank you, counsel.
Good morning, Your Honors. My name is Matt Germain. I represent Defendant Interior Builders today. The only claim against Interior Builders in this case is a common law negligence claim, so I'm going to be, hopefully, pretty brief. Your Honor, Interior Builders moved for summary judgment on two grounds. One is that Interior Builders was a non-contracting third party that owed no duty to the plaintiff. The second was that the intervening and superseding cause of the accident was the decision to move it. Now, everyone testified that this drywall was stable and that it wouldn't have moved. In fact, Mr. Hegel, the project superintendent for TimeCap, testified that short of running a lift or something into it, it wasn't going to go anywhere. So, Your Honors, what was presented was at most an inconvenience. And what happened was entirely avoidable. Rather than wait for the drywall contractors, the people who are trained and experienced in moving drywall, this decision was made without even telling them that the drywall was in an inconvenient location. And, Your Honors, I would point out that, again, and at the risk of reiterating and beating a dead horse, so to speak, this drywall was not bumped into. It didn't fall over on its own. There was no vibration in the building that caused it to tip over. The only reason that it fell is because the plaintiff, who admitted he had no training or experience in moving drywall on construction sites, decided to move it. All without even telling Interior Builders that this was an issue. Now,
well, the plaintiff wouldn't do that. The general contractor would do that.
Would do what, Your Honor? I apologize.
Tell your client.
Correct, certainly. And it's my understanding, or based on the testimony at least, the plaintiff, there was a discussion with the general contractor, but it's undisputed that that was not relayed to Interior Builders.
But if Interior Builders had stored it in a manner that it didn't partially block the entranceway to the door, then it wouldn't have to be moved at all. And isn't it foreseeable that the place the experts in drywall put it, wasn't that foreseeable that that would create a problem for someone?
Your Honor, you bring up a great point. So, foreseeable that it would need to be moved is one thing. Foreseeable that a person with no training or experience would engage in a trade that he hasn't been retained to perform, and that trade is on the job, albeit at lunch at the time. The reasonable thing to do would have been, can you move it? And that didn't happen here. And the plaintiff's own supervisor said there was no reason to rush, and it was 30 minutes. That's what we're talking about. 30 minutes for the Interior Builders crew to come back, and it would have been moved. And Your Honor, I would refer your attention to the case that we cited in our papers, Madeir. And in that case, the facts are strikingly similar. There was a long, heavy metal object, or pipe rather, that was left on the ground. The plaintiff, while preparing for work, just as what happened here, and a coworker attempted to move it. They picked it up, the pipe fell on the plaintiff's foot, and he was injured. That is precisely what happened here. And the second department in Madeira found that it's apples and oranges. Leaving it behind does not create a duty, and it doesn't make it a dangerous condition. It was the means and methods that were employed in moving the pipe that caused the accident. And the plaintiff actually in Madeira made the same argument that they should have moved that pipe so that I didn't have to. And the court found that that was not negligence. And the court dismissed that case. And this court in Abreu, it was a similar finding with a pallet rack, an unassembled pallet rack. They were moving parts, it tipped over and fell on him. And the courts, again, this court found that the subcontractor was not negligent.
We'll take a look at that, counsel. Anything further?
Your Honor, as I promised, I was fairly brief. Thank you, Your Honor.
Thank you.
That's it for me.
One more.
Last and least. May it please the court, Alan DePeters from Trebek Cristo on behalf of Syracuse Energy. I'll try to be brief as well. Rather than go through my entire argument, I really think that what my position rests on are the actual facts of the case. And what we know here is that the drywall was identified by Mr. Jesmain. Mr. Jesmain brought that to the attention of his foreman. His foreman immediately told him, don't touch it, and then went to Mr. Hegel, the time cap general contractor foreman, and said, we're not touching this. It's not our job. So Mr. Hegel, a representative of the general contractor, has now been instructed by the sub that I'm not going to touch this and I don't want my people touching it. Mr. Reisig then walks away. He goes to do other work. And we don't know exactly what happened. We know that Mr. Jesmain says that Mr. Hegel said, hey, if you help me, we can move this thing. Or if it was Mr. Jesmain that asked Mr. Hegel, there's a couple different stories there. But as I put in my papers, it's a distinction without a difference. The general contractor knew that it was not Syracuse Energy's work to move, manipulate, or handle drywall. The general contractor knew that the foreman on site had told them, we won't do this, and yet the general contractor permitted it to be done. So just like as we cited in the Pavarini case, where there was a different worker, right? There was a worker that was performing some stucco work on a roof. That was not our scope of work. And the contract very clearly identifies as a defined term our scope of work, which was the furnishing, the implementation, the construction of an HVAC system. So not only does the contract not make drywall our work, but there was a specific discussion between our company and the general contractor that we wouldn't touch the drywall. And then the general contractor went and co-opted our employee or permitted the employee to move this drywall. And so taken to its logical conclusion, as we say in our papers, if this was to be a situation where contractual indemnification was found, general contractors could just walk around the job site and ask the bricklayer to help with electrical work and then say, you have to indemnify me. Because somehow that particular employer wasn't all over them 100% of the time to physically stop them from doing something that the general contractor asked or permitted. And so at a minimum, I think that there's a question of fact for a jury to decide on that issue. Because I think that a jury could say, time cap, you knew that this wasn't their scope of work, and you knew that they had told you they weren't going to do it, and you let them do it anyway. I think a jury could certainly determine under those facts that it's time cap that is solely responsible for the action here. And then in addition to that, of course, it was Mr. Hegel that prescribed the manner in which the drywall was moved, and we just heard Mr. Germain, counsel for the expert drywall movers, indicate that why would anyone without expertise attempt to move drywall? So I think that there are questions of fact here that will preclude summary judgment at this point.
Thank you, counsel.
Thank you, Your Honor.
Okay, in case we pulled out of order, case 809, KO versus YMCA Buffalo Niagara. Justice Curran is recused on this case. I believe we have counsel appearing by video. Counsel, you're on mute, but can you hear us?
Yes, I can hear you very well. Thank you.
And we can hear you, counsel. Please proceed.
Thank you. May it please the court, my name is Stuart Mermelstein. I represent the plaintiff appellant KO in this appeal. This is an appeal from an order granting a motion to dismiss. The motion was granted pursuant to CPLR 3211A1 and 3211A7. There are two issues in the appeal. The first concerns CPLR 3211A1 and the question whether the motion to dismiss was supported by sufficient documentary evidence. This is a very, very high standard under the law. The case law requires that the documentary evidence submitted utterly refute the allegations of the complaint and establish the defendant's non-liability. Additionally, the types of items that will constitute documentary evidence are limited. They're basically deeds, contracts, incorporation records, things of that nature. What is not competent as documentary evidence under 3211A1 is an affidavit. And certainly conclusory statements in an affidavit are not valid documentary evidence under 3211A1.
Counselor, in this instance, the documentary evidence was a deed and corporate documents as well that were submitted on behalf of YMCA Buffalo to indicate that they didn't own the premises, correct?
That's correct. Correct. Although there's some question as to whether the deed satisfies that or establishes the burden in this case, because the deed submitted didn't indicate the address of the property. There were materials, many of which were illegible, so it wasn't entirely wasn't sufficiently clear under the standard for 3211A1 that this the deed documentary evidence
Isn't your claim, though, with respect to 3211A1, that deed evidence and the affidavit submitted by the CEO, I think it was, is not sufficient to determine that YMCA Buffalo was not an agent of YMCA Lockport?
That is the principal assertion, yes.
Isn't that almost in line with the JAF versus the Roman Catholic Archdiocese from this court?
That the JAF versus Roman Catholic Archdiocese?
Very similar to the factual situation here. There they said that the deed only indicated that the Archdiocese did not legally own the premises, but the deed did not foreclose the possibility that the alleged abusers were agents of the Archdiocese.
Yeah,
Isn't that your argument?
Yes, that is correct, Your Honor. The case is JD versus Archdiocese. That's why I was confused for a moment.
I'm reading from JAF versus Roman Catholic.
Okay.
They're very similar. Both cases were very similar.
Yeah, I'm thinking of the First Department case, but in any event, yes, both cases say that deeds and incorporation records will not suffice to foreclose or an agency relationship, which presents a question of fact for trial. In addition to that, here.
And as part of your argument, counsel, that I may be mispronouncing this, but the Airbar's affidavit can't be used as supplement. That's what you're saying just a few moments ago, that we're looking at documentary evidence, we're looking at deeds, we're looking at corporate records. That's what's intended under this standard, and not be supplemented by affidavits. Is that a fair synopsis of what your argument is?
Absolutely. And the Erebar affidavit, he's the president and CEO of the party of YMCA Buffalo. And he makes very conclusory statements in that affidavit. Obviously, this is a motion to dismiss. It's pre-discovery. We haven't had an opportunity to depose him. It would be the height of unfairness to accept his statements as given when there's been no opportunity to challenge it. And that's why an affidavit is not competent evidence as documentary evidence under 3211.
And it may very well be true that after discovery, which you're referring to, that a motion for summary judgment may have be appropriate, but we're not there yet, and that's your argument.
That is exactly correct, yes.
All right. You want to touch upon A7?
I'm sorry?
3211A7, do you want to
I'm
touch?
sorry, yes, 3211A7, yes. The question there is whether we have made allegations of fact that sufficiently manifest the cause of action of the complaint. There is no law that requires that successor liability be particularly pled or that it have a separate cause of action. The facts that we set out in our complaint, taking the four corners of the complaint, we allege that YMCA Buffalo owned, operated, controlled the Lockport YMCA, that YMCA Buffalo was responsible for the hiring, supervision, and training of YMCA Lockport staff. And these allegations taken together support successor liability. Given these allegations and the existence of that successor liability issue, again, we're entitled to get into discovery to flesh out that issue, and any dismissal is premature.
Thank you, counsel. Oh, was there a question?
I'm all right, thank you.
Okay, thank you, counsel.
Thank you very much.
May it please the court, Ryan Lima from Phillips Lytle on behalf of respondent YMCA Buffalo Niagara. We ask that the court affirm Justice Chimes' order. We believe Justice Chimes correctly determined that the complaint failed to state a cause of action premised on successor liability because, as pled, the complaint is completely silent as to any theory of successor liability. The single cause of action alleged in the complaint against Buffalo Niagara, paragraphs 37 to 42, are premised on the idea that YMCA Buffalo owned and operated YMCA of Lockport during the relevant time period. And the documentary evidence that was submitted, the corporate information documenting that YMCA Buffalo and YMCA Lockport are in fact two separate entities, and the deeds and real estate records, I think utterly refutes the idea that YMCA Buffalo owned and operated Lockport, which is the only theory that's alleged in the complaint. What's alleged is that YMCA Buffalo knew that plaintiff was being alleged at the Lockport facility at the time, failed to terminate the perpetrator's employment at the Lockport facility, and failed to make the Lockport facility safe. Those are refuted by the documentary evidence. So what we had happen here is, in opposition to the motion to dismiss, for the very first time, plaintiff raised this issue as to the potential application of successor liability. But that's nowhere found in the complaint, and that's the basis on which Judge Chimes dismissed the complaint as pled and without prejudice. Justice Chimes cites the Zinbard case from the First Department. We also cite the WorldCom and Intrinsic cases in our briefs, all of which stand for the proposition that if a plaintiff intends to proceed on some theory of successor liability, be it de facto merger or some other theory, there must be allegations in the complaint. You know, we don't even have a bare bones conclusory attempt to plead, you know, the elements that go into the de facto merger doctrine, for example. The complaint is completely silent on that. Justice Montour, to your earlier question, the complaint also does not attempt to allege any type of agency theory. It solely rests on the idea that YMCA Buffalo actually owned and operated the YMCA of Lockport at the relevant time, which is, I think, completely foreclosed by the documentary evidence. So unless the court has any questions, we would ask that you reply.
Thank you, counsel.
This court will stand at recess.